In the matter of B. Algeria versus Secretary of State for the Home Department.
Lord Lloyd Jones will hand down the judgment of the court.
Reporting restrictions apply in this case. The court has ordered that no one shall publish or reveal the name or address of the respondent who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the respondent or any member of his family in connection with these proceedings. This appeal raises the question whether immigration bail is available in circumstances where the individual concerned can no longer be lawfully detained because there is no reasonable prospect of his removal from the United Kingdom. The respondent, B, has a long and complex immigration history. He has been in the United Kingdom since 1993. He was originally detained under Section 21 of the Anti-Terrorism, Crime and Security Act 2001 and was subsequently subject to a control order under the Prevention of Terrorism Act 2005. On the 11th of August 2005, he was notified of the Secretary of State's intention to make a deportation order against him on national security grounds. He was detained under Schedule 3 of the Immigration Act 1971, pending deportation. He appealed using a false identity to the Special Immigration Appeals Commission, SIAC, against his deportation. On the 19th of July 2007, SIAC ordered him to provide details of his true identity, and on the 30th of July 2008, it held that the Secretary of State's case against him on the risk to national security had been made out. On the 26th of November 2010, SIAC held that B had disobeyed its earlier order of the 19th of July 2007 and imposed a sentence of 4 months' imprisonment. Following his release from prison, bail conditions were imposed under paragraphs 22 and 29 of Schedule 2 to the 1971 Act. On the 13th of February 2014, SIAC held that there was no reasonable prospect of removing B to Algeria, and the ordinary legal basis for lawful detention under the Immigration Act therefore fell away. Thereafter, the Secretary of State did not authorize B's further detention, and his bail conditions were relaxed. B's appeal against the notice of decision to deport him was struck out by SIAC in light of his continuing contempt of court. SIAC also rejected his submission that following SIAC's findings of the 13th of February 2014, it no longer had jurisdiction to grant bail to him or to impose bail conditions. This decision was upheld by the High Court. B appealed to the Court of Appeal, which on the 6th of May 2015 allowed his appeal on the ground that SIAC had no jurisdiction to impose bail conditions on B if his detention would be unlawful. On the 12th of December 2016, SIAC allowed B's substantive deportation appeal. As a result, B's bail fell away, and it is common ground that the immigration power is now unavailable. The Supreme Court granted the Secretary of State permission to appeal against the decision of the Court of Appeal on the issue of SIAC's bail jurisdiction. Following the decision of the Court of Appeal, the relevant law was amended by Section 61 of the Immigration Act 2016. However, the Secretary of State has not relied on Section 61 in this appeal, and the appeal has been heard on the basis of the statutory provisions as they were at the time of the decision of the Court of Appeal. I also note that Section 61 itself has now been repealed and superseded by a new statutory framework. The Supreme Court unanimously dismisses the appeal. The Secretary of State submitted that the legislation should be given a purposive interpretation so that bail is available regardless of whether the individual is lawfully detained or would hypothetically be lawfully detained. The Court sees no basis for such an approach. It is a fundamental principle of the common law that Parliament is presumed not to intend to interfere with the liberty of the subject unless such an intention is made clear. The principle of legality is in play here. Accordingly, the Court is required to interpret the statutory provisions strictly and restrictively. It was common ground before us that being detained is a condition precedent to the exercise of the power to grant bail. Applying a strict approach to interpretation, the Court considers that the reference to detained means lawful detention. Where it ceases to be lawful to detain a person pending deportation, there is no longer a power of detention, and there is therefore no longer a power to grant bail or impose conditions of bail. The Court rejects an analogy which the Secretary of State seeks to draw with powers of temporary admission or temporary release. The Court rejects the Secretary of State's submission that the interpretation of the relevant provisions favoured by the Court of Appeal would lead to impracticability in their application. In any event, if administrative inconvenience is a consequence, the remedy lies with Parliament. The Court finds considerable modern authority which supports the Court of Appeal's statement of principle that the power to grant bail presupposes the existence of and the ability to exercise the power to lawfully detain. However, this is not necessarily a principle of universal application. While the clearest possible words would be required to achieve a contrary result, Parliament could do so. Accordingly, the Court does not decide the appeal on this basis. In the circumstances, the Court has not considered it necessary to address the arguments under Article 5 of the European Convention on Human Rights, which adds nothing to the resolution of the issues on the appeal.